Now everybody can hear. Uh, now we're recording. Hello, everybody. Thank you for coming to ALRP's MCLE series, our August session. We recently moved from a seasonal session, or 5 to 6 presentations in the spring or fall, to a monthly session. So this is our second monthly session. And today we are doing a session on transferring assets at death. Do you really need probate? It's presented by Sandy Price, an amazing panel member and a great teacher who has done MCLEs for us in the past, and we're just ecstatic to have her with us. So I'm going to go through our agenda, and then we'll go to the substantive training, and we're going to reserve the last 15 minutes or so for question and answers. If you could hold your questions until the end, and then we'll go through them one by one. So first, and then followed by, I'll actually send the PowerPoint slides out as well, and the evaluations. You will receive MCLE credit. If we receive your evaluation, please give us 2 to 3 business days to get those MCLE credits out to you. Next slide, please. So this is just our quick housekeeping. This training is being recorded, and all participants are muted until the question and answer session. In fact, muted even then. Please use the Q&A box to write your questions. You must complete the evaluation to receive MCLE credit. Again, I'll send the link towards the end of the presentation. And if you have sent in your evaluation, or if you've not received the actual materials to go along with this, please send me an email and I'll try to get them out to you. Next slide. So ALRP's mission is to advance, protect the rights, dignity, and health of people living with HIV/AIDS in the Bay Area. Next slide. Looking at the numbers, I want to draw attention to a couple numbers for you. 78% of clients are living on an income of $30,000 or less, with 55% of clients living on an income of $15,000 or less. As you can see, we've handled in 2024 over 2,000 legal matters handled, and nearly 1,300 unique clients assisted. In this day and age, with Trump passing his big, beautiful bill, there's been cuts to all manner of social services and everything else. With people living under $30,000 or less, ALRP attorneys are often the last line of defense, helping them with their various issues. We cover everything from immigration to trust and estates and probate to bankruptcy to civil litigation and especially housing matters. Next slide, please. We rely on our panel to provide those low-cost legal counselings and representations. And we, of course, tailor the experience of our panel attorneys to their experience and availability. For those attorneys out there who are interested, we only ask that they accept 2 referrals a year. And of course, there's the option to accept or deny the referral when contacted. And the many benefits of being a panel attorney, of course, receive free MCLE trainings like today's. Mentoring, malpractice insurance, and legal resources, including interacting with a number of our peer organizations and co-sponsors. Next slide, please. So if you want to join the panel or otherwise volunteer, please reach out to me or use the handy link there, which will take you to an application on our website. If you're not an attorney or unable to volunteer for the panel, we can always use your help. If you want to donate, please use the link there or contact SLOCA. We are happy to talk to you about any help you can provide. Next slide, please. We all, of course, want to thank our co-sponsors. Long list of amazing peer organizations doing a lot of great work in the Bay Area. Next slide. And just a reminder, our 42nd annual reception is on October 23rd at 5:30 to 8:30 at the Grand. This year, I am pleased to announce that we will be honoring George Takei, who, of course, is a Hollywood legend, best known for playing Lieutenant Sulu in the original Star Trek series, and got promoted at the end of the movies to be captain of the USS Excelsior. He is also an LGBTQ+ advocate and one of the leading voices in the remembrance of Japanese American internment during World War II, where Japanese Americans were interned without due process to camps in the middle of nowhere. All of a sudden, it seems that the more times change, the more they stay the same. So please go to the link Buy tickets and come meet George Takei. He would love to see you. Oh my. So that takes us to our presenter, Sandy Price, who's a partner at Seidman Bancroft and one of our wonderful panel attorneys, and has presented on probate and trust and estate matters before. We are just exceptionally happy to have her, and please give her a round of applause. She can't hear it, but we'll appreciate it. It's all yours.
Okay. Oh. So I think that concludes the housekeeping part of the program. Now we're going to get into the substance. And I was always told when you're giving a talk, first you explain what you're going to cover, you cover it, and then you summarize it. So here is what we're going to cover today. Some introductory comments, and then there's one category of assets that can pass without probate. We're going to talk about those. Then there's another category which by statute you can doesn't need to be probated. We're going to cover those. And then I'm just going to briefly go over what the probate process is, what you can expect if there's no workarounds that help you, and you'll wind up having a better understanding for why probate is to be avoided if at all possible. And then finally, by way of summary, I have a hypothetical that we're going to go through so that you can actually see how powerful these various tools are. The hypothetical is someone, a surviving spouse, walking into your office with $5 million worth of assets and several different beneficiaries, several different kinds of assets. And I know that sounds like something that would need to be probated, but we'll work through whether that's actually true or not. So I also wanted to mention that you should have a fairly lengthy handout, and attached to that handout are about 20 pages of forms that I'm going to be mentioning as I go through the talk. They're not part of the PowerPoint presentation, but they are attached to the hard copy handout. So so they're there for you for future reference. As a sort of brief introduction to how this program came about, I am available as a resource to panel attorneys who are helping people after someone has died. And I was getting a lot of calls from those attorneys who hadn't done probate before, were unfamiliar with what happens, and they were asking me all kinds of questions about commencing the probate. And when I talked to them, it turned out they actually didn't need to open up a probate. There were enough workarounds, and they could fit into one. And avoiding probate really is a good thing. So I decided to collect all that information in one place and present it as a program. So that's what we're doing now. You're getting the benefit of all the collected information. So I wanted to start with some preliminary thoughts. And one is, what is probate? And probate is just the court-supervised process that does a number of things. It establishes the decedent's last valid will or confirms that there is none. It identifies the proper heirs and beneficiaries. It identifies all of the decedent's assets and liabilities, ensures that only one person is speaking on behalf of the decedent's estate, and it provides a forum for anybody to contest anything. It also provides a forum to make sure that everything is done properly, because the court is always looking over your shoulder. That is one of the downsides of probate, is that you have to continually be asking for court approval. Those all sound like really good things. So why does everybody hate it? And it's because it can be costly and time consuming, and it's also very public. whatever, when you die, whatever you own that needs to be probated gets inventoried so everybody can see. I mean, and in San Francisco, it's part of the court record. It's part of the public record that they could see what you own and what it's worth. And then there's also a copy of your will that's provided there, so they can see, anybody John Q. Public can see exactly what a beneficiary or heir is going to be inheriting. And to put this in context, if someone dies and say his wife goes to the bank and says, my husband died, close the account, I'm going to take all the money out. The bank, of course, is going to say, why should we give it to you? How do we know you're the person entitled to it? And what if she shows up and says, look, here's his will. It says everything goes to my surviving spouse. Well, how does the bank know that she actually is the spouse? How does the bank know that that's the last will? The bank is still going to have a lot of questions. What if it turns out that the will said that it goes to my children? So not the wife. So one of the children shows up with the will to the bank, wants to close the same account. The bank goes, well, how do we know that you're the only child? How do we know that this is a valid will? You can appreciate that for liability purposes, the bank is really not going to want to move. Same thing. You get the idea that it serves the purpose. Probate are kind of the rules that society developed to have the court supervise the process to make sure that all of the purposes on this slide are being satisfied. This is just sort of another introductory thought because there's a lot of misinformation about what happens after someone dies. The authority of an agent under a durable power of attorney is not effective once a person dies. So the person who might have been their agent during lifetime and could have accomplished a lot of financial and legal matters under the authority of that durable power of attorney can't rely on that anymore. Another misconception that a lot of people have is that they're the attorney, is that they're the executor or the administrator, which are essentially equivalent functions or equivalent roles. And at the foot of page 2 of the outline, I kind of go into that in a lot of detail in a footnote. So only the personal representative appointed by the court and who has court papers that are called letters is actually has authority to do anything on behalf of the decedent or the decedent's estate. It is not enough that you see your name in a will. That does not give you any power at all. So getting into the meat of the matter here and avoiding probate if you can. So there's a two-prong approach that I use whenever I'm presented with, when someone walks in my door with, someone's just died and they have a lot of assets and I have a copy of the will. So first, you identify non-probate assets. Those can be any size at all. And those are assets that pass directly to the beneficiary, either because of the way title is held or because it's something like a life insurance policy or an IRA, where part of the contract you have with the entity, the IRA custodian or the life insurance company, is that by contract, they just know who to pay. And then once you basically erase those, get those out of the way, then you look at what's left and you see if there's any statutory procedure that applies that will eliminate the need for a probate. If you eliminate all the assets, then you don't need to open a probate. If there are some remaining assets that for one reason or another you can't erase by either of these two bullet-pointed approaches, then you probably do have to commence a probate. So This is just to remind everybody that in California, spouses and registered domestic partners are treated equally. This is for further information. There's a few resources that are helpful. The Rudder Group and the CEB, Decedent Estate Planning Practice, which is a 2-volume treatise. And in the CEB Action Guide, I think that's out of print. I think they stopped printing that, but it still should be available like in law libraries, and it's pretty helpful. Okay, so part 1 of my 2-prong approach is non-probate assets passing directly to a beneficiary. First, there's things like life insurance, death benefits, retirement, and profit sharing plans. And in general, these can be collected immediately. There's no waiting period. Whoever is entitled to it needs to approach the person, the entity or institution that's holding the assets you're trying to collect. So life insurance or annuities, employee death benefits, including union death, Social Security benefits, and then retirement pension and profit sharing plans. This includes IRAs. So it comes up fairly, so all of those pass by beneficiary designation, and it happens, unfortunately, frequently, that there is no beneficiary designated, either because the person who was designated has predeceased the decedent, or because they just never named a beneficiary. So what happens if there is no beneficiary designated depends on the plan, and there's usually 2 sort of flavors. The policy or plan will default to the decedent's probate estate, which is not a good thing. That means that depending on the amount, you may actually need to open up a probate proceeding just to have an executor appointed to deal with the IRA or pension plan or life insurance company in order to collect those benefits. Other policies have sort of baked into their contractual terms that the decedent's heirs at law receive the benefits, in which case, once those people are identified, they can approach the life insurance company, the retirement plan, whoever it is, and go through the process of trying to collect the benefits. Then there's the actual mechanics of what you do, and it depends on what kind of asset it is. Life insurance and other death, you have to request the appropriate claim form from the insurance company. I have to say, all of these things that I'm calling mechanical can actually be a really annoying amount of paperwork, especially as companies are becoming the subject of fraud more and more often. They make you jump through more and more hoops in order to collect benefits that you shouldn't have to spend so much time collecting. And invariably, if you have 2 life insurance policies that you're named the beneficiary of, each life insurance policy is going to give you a different runaround. It's just kind of the way it is. There isn't really any way to get around it. So for life insurance and death benefits, you contact the company that's holding them. Social Security benefits, you have to contact the Social Security Administration. For government benefits, you have to apply to the particular administration that's involved. And then retirement benefits, you have to contact the custodian or plan administrator. And sometimes you do get into this situation where, for instance, the surviving spouse assumes he or she is the beneficiary, and they go to, reach out to the IRA custodian, and the IRA custodian says, oops, it's not you, and we're sorry, we can't tell you who it is. So you kind of have to play sometimes a little bit of a round robin of people approaching, because they're not at liberty to really disclose who it is. Okay, the next kind of asset that passes directly to a beneficiary is joint tenancy property. So that'll be like a deed that reads husband and wife as joint tenants. Often it says husband and wife with right of survivorship, and you can sometimes see it as JTWROS. Some title companies do that. I'm not sure why. So the principal feature of that is that each owner's interest automatically passes at death to the surviving joint tenants. Even though it's automatic by law, you still have to take some mechanical steps so that the world knows that the person died and that the surviving joint tenant or tenants survived to actually own it. So if it's real property, you have to record an affidavit of joint tenant. And in the materials at my handout at page 5, I give you one link to get an affidavit of death of joint tenant, and I've also got a copy of it at page 17 and 18. And it's just a matter of filling out the affidavit, attaching a certified copy of the death certificate, and recording that. And that's the way to perfect title for the surviving joint tenant or tenants. For corporate stocks and bonds, or for treasury bonds, you need to contact the transfer agent and see what they're going to want. Same thing with bank, brokerage, or mutual fund accounts. If it's X and Y as joint tenants, the bank or broker is going to tell you exactly what they want and give you the forms. So for another kind of asset passing directly to the beneficiary, this applies. I keep thinking this is new, but it's actually been more than 2 decades. If title is held as community property with right of survivorship, and it actually has to have those exact words, then the surviving spouse can collect the asset. And the reason that this was created, instead of just having it be joint tenancy between a husband and wife, is that this not only gives you the ease of having to of just recording a deed or contacting a bank or brokerage and saying change the title to me, I'm the surviving spouse. It also allows the spouses to take advantage of an income tax aspect that would allow them to get a stepped up basis on both halves of the community. And I'm not sure if anybody's interested in drilling down on that now, but if you want to understand it more, we can talk about it at the end of the program, or you can reach out to me separately. Again, notwithstanding the title passes automatically, you still need to take additional steps to make it happen. It doesn't happen by itself. So an affidavit of death of spouse is another form that I discuss on my materials at page 6. And I have a sample of one on pages 19 to 20 of my materials. And my materials walk you through more steps, more details on how to make it happen. And then again, corporate stocks and bonds and bank, brokerage, or mutual fund accounts, you have to contact whoever is holding the property in order to see what they will want. Certain kinds of vehicle registrations, you don't have to probate. And the DMV has its own form, which is at page 21 of my materials, for transferring a vehicle without going through probate. And it is actually titled Affidavit for Transfer Without Probate, California Titled Vehicle or Vessel Only. I didn't include vessels in my materials here, but if someone has a boat, they could also qualify for this procedure. And the DMV website has additional information, and this is a pro tip that if you're a member of AAA, they may be able to assist. That is one of the things they do, is help with registration. So if you're re-registering as a result of a death, they can be really helpful with that. Okay, so beneficial interests under trust also don't need to be probated. So if my dad, when he died, set up a trust for me, and the trust says it's for Sandy during her lifetime, and then when Sandy dies, it goes to Sandy's children, my beneficial interest under that trust does not need to be probated. The trustee looks at the trust instrument, knows exactly what to do when I die, and just goes ahead and does it. And then revocable living trusts are a major probate avoidance technique used in California. So I'm not sure how familiar people are with that, but I'll take a minute to just go through a little background. So with a revocable living trust, I would set up a trust instrument, Sandy's Revocable Living Trust, and I would, it would sort of proceed in chapters. The first chapter would say, while I'm alive, I'm the only person involved in this trust. I'm the trustor, the person who set it up. I'm the trustee, I'm taking care of it, and I'm the beneficiary. So it's a big triangle, and it's all for me. That's chapter 1. Chapter 2 would be when I die. And let's say when I die, there's a successor trustee who is named in the trust instrument who would take over, and that person would then follow the trust instructions to distribute the property the way I've specified in the trust instrument. And sometimes trust instruments can get really complicated, because sometimes they go for 3 or 4 chapters. It could be while I'm alive. Then if I die and my husband survives me while he's alive, it could be, then it goes to my children, then it goes to my grandchildren. So the revocable living trust instruments can be either fairly simple or very complicated, and particularly if people are trying to include some tax savings features in a revocable trust, and they're putting in all the bells and whistles that the IRS wants to see, it could make for even more complication. And usually the provisions are way more detailed than take care of the assets and then give them to my child. There's pages and pages of boilerplate about what kind of investments you can have, what things like that. But anyhow, so I set up this revocable living trust for myself as an estate planning technique that I'm using, and then I transfer title to all of my assets to the revocable trust while I'm alive. So instead of my house being titled as Sandra Price, a married woman, as her separate property, it's going to say Sandra Price, trustee of the Sandra Price Revocable Living Trust. And then what happens when I die is that whoever I've named as successor trustee steps up and simply distributes the assets as I've directed in the trust instrument. There's no need to get the court involved. So revocable living trusts are a big feature of estate planning in California, and the reason is to avoid probate. So some other assets passing directly to a beneficiary are bank accounts and brokerage accounts that are POD or TOD. That's pay on death or transfer on death, and patent trust accounts. Those are basically accounts at a bank where if I set one up for myself, naming my daughter as the POD beneficiary, my daughter has nothing to do with it while I'm alive. She has no access. She can't get information about the account. But once I die, she just has to show up at the bank and with a death certificate and say, I'm the pay on death beneficiary. Please, please close the account and give me a check, or please open a new account here at this same bank. But those are very effective for avoiding probate. Sometimes there can be unintended consequences, however, if people die out of order, and if you're intending your children to get equal shares, but under your will, and that's what your will says, but someone is a pay on death, one of your children is a pay on death beneficiary, they're actually double dipping. So sometimes just willy-nilly setting up these accounts can, skew what a person intended their plan to be. Okay, so again, the collection of assets is just, you have to approach each institution and they're all going to have their own forms for you to fill out. Okay, so fairly new is something called a revocable transfer on death deed, sometimes referred to as a beneficiary deed. And this is inexpensive and it's quick. And basically, the deed says it's a pay on death deed, except it's a transfer on death. It's like a pay on death account. The person who's named as the beneficiary can't do anything while the person who set it up is alive. But once the person who set it up dies, it springs into effect, allowing the beneficiary to very easily change title. And again, this is, even though the law provides that title passes automatically, you've still got to do something mechanical to show that that happens. So, I actually also in my materials on page 8 discuss this, and another affidavit to record, this one called an affidavit of death of transfer under a TOD deed. And on pages 23 to, there's a typo in my materials, it says 23 to 23, and it's actually 23 to 24 is the affidavit to transfer a revocable transfer on death deed. And this was really a hard fought battle to get this enacted. There was one legal services, pro bono legal services agency in Los Angeles that was really pushing for this. And what happens in California is most laws are reviewed by the Judicial Council for comment, and they solicit comments. And I'm a nerd. I usually read all of the comments to proposed legislation, and they're always really dry and academic, and they're from, professors and, attorneys who just really like to get in the weeds. So they're very dry, and there's like usually 3 with respect to anything probate or trust related. When this came up, the Judicial Council received just hundreds of handwritten, for the most part, emails, not emails, this is before emails, handwritten notes from people that said, please don't make me have to pay an attorney so that my kids can get my house when I die. Please enact this. And it took a while because the Bankers Association and some of the real estate associations were very opposed because of all the kind of mischief that might occur, but we finally got it in 2016. So, okay, so now that is finishes my discussion on non-probate assets. Now we're going to switch to talking about some statutory alternatives to probate. And this is just largely driven by the fact that the legislature recognized that not every situation when someone dies needs to have the court supervising it. The courts are too congested and overworked as they are. So let's get realistic and not have every person who dies have to go into court. So one of the biggest exceptions is called a spousal property petition, also available for registered domestic partners. And this is really useful in a lot of situations where there's a surviving spouse. There is no limit to the amount of property that can be distributed using this procedure. If someone died with $10 million and left a will that said, I leave it all to my spouse, the spouse could file one of these spousal property petitions and collect all and get an order confirming that she's entitled to all $10 million. So it's in some ways limited. Only a spouse can do it. And it has to be given directly to the spouse. If the decedent's will says, I give all my property to my spouse in trust for her lifetime, that won't work. It can't work if you say, I give my property to my spouse and my daughter. The spouse can't just do an end run around and collect hers. The whole thing has to be probated. And there's a 40-day waiting period. And the advantages are that this is really quick compared with a formal probate. It's, for the most part, private. It's private to the extent that the values don't need to be in the public record, but the assets that you want, that the spouse wants, do need to be part of the petition. Some disadvantages are, one of the advantages with probate is that creditors have a defined period where they need to step forward to make a creditor's claim against the estate. And if they don't, then they lose their rights. So using this, you don't get that kind of, using this one-shot petition, you don't get that kind of protection. If there's out-of-state real property, you're going to need a full probate in that state anyway. So the mechanics, it requires a petition to the court. And I have my materials at page 9 discuss this in more detail. And I did attach the judicial counsel form for the petition and for the order that you get from the court. Those are pages 24 to 26. And what happens is once you get that court order saying all of this property passes, and the property is enumerated, all of this property passes to the surviving spouse, you take that order, and if it's real property, you record it. If it's a bank or brokerage or mutual fund account or anything like that, you go to the institution, and that is their authority for giving the surviving spouse the asset. Most banks and brokerages don't really care what kind of court order they get, whether it's a probate order of distribution or this kind of order or one of the other orders I'm going to talk about in a few minutes. They just need something so that they're not you know, so that they're off the hook, that they gave it to the wrong person. It is a noticed hearing, and you don't have to inventory, you don't have to value the assets if you don't want to. There's no statutory attorney's fees. It's just whatever the surviving spouse and his or her attorney agree on. So there's another procedure called collection by affidavit, sometimes called a small estate affidavit, and this is for probate code section 13100. That's not on the PowerPoint, but if you are taking notes, it is in my handout. It's 13100, and this is not for real property. It's only for personal property, and it's very useful for small estates. So there is a cap on the amount that can be collected using this procedure. It's not unlimited like the spousal property petition, but the court is also not involved with this at all. For deaths on or after April 1st, the amount of the cap is $208,850, and that'll be adjusted for inflation. And there's a law underpinning that, but also Judicial Council Form DE 300 sets out what the amounts are. And on page 29 of my handout, you can see what Form DE 300 looks like. And this is great if someone dies with, you know, one or two bank accounts that total $30,000 or something. You just fill out this declaration and go to the bank with it. And basically the way the law works is that unless the bank has some reason, and the declaration basically says, I'm the person entitled, so-and-so died, here's a certified copy of his death certificate. I'm the person entitled to it, either because I'm an heir at law, because there was no will, or because I'm the beneficiary under a will. And I declare under penalty of perjury that this is all correct. And basically, unless the bank or whoever is being presented with this affidavit has some reason to suspect that there's something wrong, they have to turn the account over. If it turns out that you lied or were misinformed and you were not the person entitled to the account, the law leaves it up to the person who got it and the person who should have got it to work it out between themselves. The bank is out of the picture. And as I said before, a lot of these rules are developed to protect institutions from liability where they did the wrong thing. So this is another good example of that. There's no Judicial Council form for this, but the statute does provide the exact wording. And on my handout on page 11, I discussed this, and there's an example of the affidavit on pages 27 and 29 of my handout. There's an affidavit procedure for real property of small value. This has very limited usefulness, particularly here in the Bay Area, because it's capped at $69,625 for deaths occurring April of this year, and then it'll be adjusted in 3 years. It requires filing an affidavit with the court. There's no petition, there's no hearing. It's just you file the affidavit, and the court clerk basically makes sure that you checked off all of the boxes correctly and will stamp it, and then you can file that affidavit with the court, with the county recorder to affect transfer of real property. I have been able to use this twice in my entire decades-long career. Once was actually for a studio apartment in a retirement home here in San Francisco. Because of the fact that it was a retirement home and there were like so many restrictions on who could live there and how you could sell, we actually got it appraised for under, I think it was $60,000 at that point. We actually got it appraised for that little bit of an amount, and I was able to use it for that. And I once had someone with some oil and gas interests that were real property near Rancho Cucamonga, and we got those transferred using this. Okay, so what happens if you don't have if you don't have under 69,000 of real property? Do you have to probate it? It used to be that you there was section 13100 allowed you to transfer property up to about 200,000 or something, but and it could be it didn't. That changed dramatically effective on April 1st, 2025. This is the law changed so that you can transfer $750,000 of the decedent's interest in the bill in his or her primary residence without having to open up a formal probate. It is a petition to the court, and you do have to notice interested parties. You do have to wait 40 days, but this is going to really make a big difference. Maybe not so much in the Bay Area because values are so high around here, but it will make a big difference in other parts of the state where the values aren't so appreciated. But even so, this is $750,000 of that's gross value, not equity. So it's gross value. But if some young person who owns his flat with two of his best friends and the flat is worth $1 million, if he died, his interest in his primary residence is worth less than $750,000, and he could use this expedited procedure to transfer his property, to transfer his interest in that condo. I do discuss this more in my handout starting on page 11. And I do have attached judicial counsel forms at pages 33 through 37. And for this particular petition, you also need to file an inventory and appraisal, which is a particular probate court, which is a particular probate judicial counsel form. And the appraisal needs to be conducted by a probate referee, which is a state-appointed appraiser. So it gets a little bit. There's a couple of steps, but it's so much better than a full probate. Okay. There's probate code section 6600 also provides to set aside $89,500 for a surviving spouse. This does require you to go into court. It's a petition and it's discretionary with the court, but again, it avoids a full-length formal probate proceeding. This is not a biggie, but sometimes it can be really helpful. This is an affidavit procedure where the surviving spouse can collect wages and employment for compensation up to $20,875,000. There's no waiting period. There's no judicial counsel form, but the probate code sets out the required language for the affidavit. Okay. Finally, in my practice anyhow, I come across a lot of situations where the estate plan contemplates that all of the assets are going to be owned by the trust, the revocable trust, at the time the person dies, so that you've eliminated the need for probate. And what happens more frequently than it should is that there's an asset that it turns out he or she died with that's not in the name of the trust. And sometimes it's a big asset. They took their house out of the trust because the bank wanted them to do that when they were refinancing. Sometimes it's just a bank account that has $210,000 in it when the small estate affidavit has a limit of $208,000. So there are times where the plan is to not have anything outside the trust at death, but somehow that just didn't happen. So this is a petition to the court that says, look, I know that it's not in the name of the trust, but it was supposed to be in the name of the trust. Court, can you please just issue an order that it is trust property? And there are three principal cases that give the court the authority to do that. Hegsted was the original case, and in fact, these are sometimes called Hegsted petitions. And that was the first time that the court said, okay, you listed your house in your revocable trust, but then you didn't go ahead and record a deed, but we're gonna allow it anyhow. Cooker versus, I can't remember off the top of my head now. One of these involved a bank account that was not in the name of the trust, so extended Hegsted's real property ruling to personal property. And one of them, I think that was Cooker, and then I think Uxted said, even if you didn't specifically mention that a particular bank account, if you indicated that you intended all of your assets to be governed by the trust, then we'll still give you the order you're asking. And then, as I said before, if once you get that order from the court saying, okay, this is a trust asset, then you can record that, or you go to the bank or brokerage and show them the court order, and they're happy. They don't need an order of final distribution. They just need something from the court so that they're not subject to any concerns about liability. Okay, so that's sort of the last, and my handout does go into more detail on that, starting on page 13. So that sort of is the end of all of the end runs around probate. And if those don't work, probate involves, first you have to petition the court to admit the will, or to confirm that there is no will, that the decedent's assets will pass by intestacy, and appoint a personal representative, the executor or the administrator. That's a noticed hearing, publication in newspaper of general circulation. Anybody can look at what your will says. Anybody can, pipe up at that point and say, wait a minute, I have a later will, or wait a minute, when the decedent signed that will, he was incapacitated. He had dementia at that point. That is not a valid will. So after you petition the court, the hearing is set about a month later. During that month, you publish so that the world knows what's going on, and you have to send notice of the hearing to beneficiaries, and that does provide the forum for anybody to pipe up with a problem. And in some situations, you see someone petitioning for a to open a probate, and it hasn't even been decided whether a particular will is the last valid will. It hasn't been determined whether whoever is asking to be appointed as executor got appointed. The hearing hasn't been held, and even before the hearing, there's 10 or 15 notices from creditors filed because they want to get first. They want to make sure that their claim is being part of the record. But assuming nothing goes wrong and the will is admitted and the executor is appointed, you get court papers that say that. Then the person who's the executor has to identify all of the assets that were in the decedent's name and get appraisals of them. They have to file an inventory and appraisal with the court. They have to handle creditors' claims. They have to manage the estate assets during administration. They have to petition. And then after all of that is done, after they've identified the assets and the liabilities, they've paid all the debts, they've paid any taxes, then they can petition for issuance of an order of final distribution. And incidentally, the time lag between the court appointment of personal representative, the third bullet point, and the petition for an issuance and order of final distribution is never less than 6 months. That's the absolute rock bottom, quickest this can happen, and usually it takes much longer. Once you so you petition for an order of final distribution, invariably the court is going to have some questions. Hearings get continued. Eventually, though, you wind up with an order of final distribution, and the executor acts on that and distributes the assets the way the court ordered, and then the executor has to file receipts to prove. The beneficiaries have to sign receipts to acknowledge that they received what the court directed them to receive under the order of final distribution, and then eventually the personal representative gets discharged. As I said, the minimum time is 6 months. That never happens. It's usually more like a year, and it's frequently years, depending on the kind and value of the assets and whether the beneficiaries are difficult, those kind of things. Okay, so this is a hypothetical case. So you need a probate. So surviving spouse walks into your office and tells you that her husband recently died owning the following assets. Now it's really important in figuring out whether you can avoid a probate, to have as much information as you can, not only about what the assets are, but the ownership and the title are really critical, because, as I said earlier, joint tenancy property just passes to the joint tenant. You don't even have to think about that. You just tell the joint tenant to do what he wants to do, what he needs to do or she needs to do. So it's $5 million of assets. If this was a probate, because the legal fee for the attorney for the executor is a statutory formula, a $5 million estate would have a very nice probate fee, but you don't want to be ginning up fees when you don't need to. So the first thing you do is analyze whether you need to have a probate. And also driving this analysis is, what did Mr. Smith's will say? So it said he gives to his son and daughter off the top, sort of the remaining balance in a bank account he inherited from his grandfather, but he gives everything else to his wife outright. So if you want a sneak peek, you can, my material, my handout at page, what is it? At page 16 confirms that you don't need a probate proceeding. And I will explain why. Using my, it's not patented, but the way I approach things is that you look for assets that pass directly to a beneficiary, either because of the type of ownership or because it's an asset with a designated beneficiary. So looking down this list, the first thing is you can see that the mutual fund, $500,000, is in a trust for Mr. Smith. Let's just assume his father set it up for him, and the trust says for Mr. Smith while he's alive, and then when he dies, it goes to my other child. So this will never need to be probated. You can just erase that. It comes off the top. Moving down the list, the rental property valued at $1 million is in joint tenancy with Mr. Smith's sibling. That is not going to be probated. You need to tell Mr. Smith's sibling to go talk to a lawyer and see what about recording something so that title is in his sole name. The life insurance and the IRA, those pass by beneficiary designation, so they get erased. So that only leaves you with the cash, the stock, bonds that are community property, the residence that is separate property, and the bank account that is separate property that under the will goes to Mr. Smith's children. So what can we do with those three remaining assets, which actually have a lot of value to them? So first of all, the bank account is under $208,000. And it's important to realize that you don't count any of anything passing by beneficiary designation or anything that the surviving spouse can collect without going to probate. So the children, the son and daughter, can just go to the bank and present the bank with a declaration or affidavit under Probate Code Section 13100 that says, my dad died, we're the people entitled to this account, we're not lying, we're doing this under penalty of perjury, and the bank will turn that bank account over to them. So then what's left? There's community property of $2 million, cash, stocks, and bonds, probably in a brokerage account, Merrill Lynch or something. And then there's the house valued at $1 million. Well, even though the value is so large, $3 million, Mrs. Smith can file a spousal property petition. It's just a one-shot petition, excuse me, that will give her an order confirming that those assets should pass to her. So no probate is needed. Nifty, huh? I did want to mention with those spousal property petitions, and I mentioned it's included in my handout, but the spousal property petition only deals, can only deal with the decedent's half of community property, but it's also set up, the judicial council form is also set up so that in addition to getting an order awarding Mr. Smith's interest in this $2 million cash, stocks, and bonds, you can also ask the court for an order confirming that the other half is indeed Mrs. Smith's, because it's her share that she always owned and that she's continuing to own. So sometimes that can be helpful when you're dealing with a bank who might want to know, well, we need to know what to do with the other half. So that concludes my official presentation. And I'm not seeing any questions. Can that possibly be correct?
Oh, we do have questions.
Oh, good. I'm glad because I'm not seeing them. Okay.
Okay, I will read off the first one from David. What kind of assets receive a step up in basis? Does that mean that a new cost basis is established when the assets are inherited?
Okay. So I did say I would get back to that, so I will. So community property has a unique feature, which is that both halves of the community property get a step up in basis at death, not just the half that the deceased spouse owned. So if Mr. and Mrs. Smith owned, 500 shares of PG&E stock, I'm not going to get into a detailed thing. It's just that if they owned it half and half and it wasn't community property, when Mr. Smith died, only his half would get the step up in basis. But if it's community property, both halves get the step up in basis. So especially for highly appreciated or even moderately appreciated assets, getting the step up on both halves is really an advantage. And it used to be that the only option, if you wanted the easiness of it passing to the surviving spouse, was joint tenancy, but that only got you a step up on the decedent's half. So with this new, relatively new community property with right of survivorship, you get the step up on both halves, and also the ease of instant transfer. Does that answer the question?
I think so. Second question from David. If you could recommend one resource or book that provides an overview of avoiding probate, what would it be? Single book
Ugh.
resource.
Any of the three resources that I included at the beginning in my introductory remarks, and I know you asked for just one, but if you can find the action guide, that is probably the best one because it just deals with avoiding probate. The other two are bigger treatises that touch on a lot of things. So you need to sort of maneuver around in them to get the information that you need.
Okay, let's
And my
see.
apologies to everyone. I know you've been seeing my side view because of my setup here. This is what I look like, full view.
No worries. Is there any other questions out there? We have a bit of time, so don't feel like we're rushed. Aha, another one comes in from anonymous attendee. If someone never set their will in place concretely, i.e. notarized, but we found wishes written down in their home, will this need to go to probate? I have a client who expresses wishes for his family not to inherit his assets. Assets include a car, a union pension, savings, etc.
So in California, wills are not notarized anyhow, and a will that's notarized will not actually be effective. It needs to be witnessed by two impartial, independent witnesses. Although with litigation, you might be able to get it admitted if notarized. But California is one of the few states that recognizes holographic wills. So if a will is completely written out in a decedent's handwriting and is signed and dated, it will be acknowledged as a will. So we had a great case in my former law firm where someone left a Post-it on the refrigerator that said, I leave all my assets to my, I think it was the opera, signed
Ooh.
it and dated it. And his family was out of luck.
Yeah, but
And they
everybody
didn't,
else
and they didn't,
benefited though.
and they also, I think he did it that way because he was sure he would rifle through through the paper, his desk, and he thought that this would be overlooked. But anyhow, so it really depends on, to answer the question posed, it depends on whether it was signed and dated. And there's been recent, in the past like 5 years maybe, changes that a will, for instance, that only has one signature can be admitted to probate if you jump through a lot of hoops to impress on the court that it was what the person wanted. So it might be an uphill battle, but it might be a winning battle. So.
It's like we have another question, or rather a comment from Allison Trent. Thank you. I am from Shanty, and this is very helpful to know.
Oh, glad to hear that. So.
Okay, well, are there any more questions? Oh, wait, another one just popped right up. From Summer. How would you handle a case involving a business partner's death when the business interest was not listed as an asset? Ooh, good question.
What do you mean listed? As listed where?
In the trust.
So I'm going to give you a lawyer's answer. It depends. If it wasn't listed on a schedule to the trust, but there was other language in the trust that indicated that I declare, if the trust says I declare that all the assets I own, including but not limited to those on the attached schedule, or a lot of attorneys, when they're doing estate planning, do a separate standalone general assignment that says I transfer all my assets, including but not limited to the following. You should read those 3 cases, and there's a whole line of cases to see whether you fall into, whether you can make a colorable argument that the decedent just intended his business interests to be in the trust, but for some reason didn't intend to. And then when I do those Hegstead petitions, I always try to impress on the court that assuming you have a will that's a pour over will that basically says I leave everything to the trustee of my trust, which means that anything that wasn't in the trust pours over to the trust, so that they'll all be administered and distributed the way the trust provides. If you have a pour over will, I always try to impress on the court that it really doesn't matter, whether you go the short route, which is give me an order putting it into the trust now, or the long route requiring us to go through a full probate proceeding. It winds up in the same place with the same beneficiaries. And in fact, the beneficiaries' interests are better served by the less expensive one-shot Hegstead petition than a full probate. I don't know whether that ever has turned the tide, but I feel like it's important to make that point, that it's just what route you're taking. It's not where what's going to happen to the assets. So one other question about the business assets. So was it a corporation or an LLC or something like that? Because if it was a sole proprietorship, then, well, never mind. It couldn't be a sole proprietorship if there was a partner. Never mind.
It was an LLP.
Yeah, okay. Yeah, so.
Any other questions? We still got time. Anything at all? It's a very complex subject. Any oddball situations that are not ordinary? Anybody? To answer somebody else's question, for the MCLE credit, I just sent out the PowerPoint slides and the evaluation link. Fill out the evaluation and you will receive MCLE credit. Any other questions? Going once? Going twice? Okay. Well,
You're,
I
you're
think,
also welcome to contact me. My email is on the cover page. I'm happy to answer questions. So,
and you should, because she's amazing. She will answer every question, believe me. Any, okay, well, I guess that we have no more questions. And, we had a maximum of 42 people, which is a very nice MCLE session. I want to
right.
thank Sandy. This was
Uh,
amazing.
Such a
And
fascinating subject.
I mean, it is because let's face it, a lot of people don't know the first thing. And in a lot of cases, they can avoid a lot of heartache just simply finding out more about what needs and what not, doesn't need to go to probate. And I've seen, I've had friends or families who had spent a lot of money when they probably didn't have to. Um, if they had just come to see you, for example, they could have avoided a lot of them, a lot, like years worth of mess. Oh, wait. Oh, look, we don't have questions, but Patricia and Jeff both say thank you. It was very helpful.
Great. Thank you.
So, if, like I said, the PowerPoint slides were sent by email. I noticed that it was like 20 plus megabytes. So I guess that's pretty big. If I just sent them about 5, 10 minutes ago. So if you didn't receive them, it's possible that they bounce back because of the size of the file. I'll try to find a way to decrease. It must have been some of the graphics or maybe the picture I noticed the ALRP annual reception slide was a little big, but I'll try to reduce that so we can get it to some folks who may have size restrictions on their email. Like I said, the email I sent with the evaluation link, please do fill it out and you'll receive your MCLE credit in the next 2 to 3 business days. If you did not receive the materials that go along with this presentation, email me. I sent them out about, I think, 10 minutes before we started. But beyond that, thank you again, Sandy. It's been amazing. And again, another person says it's a great class and they really appreciate the attention to detail, which I think is exceptionally important. The slides are great. They look great as well. So amazing job. I just want to remind folks that we'll be having another MCLE session in September. We have not announced the date or the subject. And please take a look at your emails for the annual reception link for October 23rd. Again, George Takei will be joining us. So we'd love to see you there. So thank you, everybody. Thank you, Sandy, and everybody have a great day.
Thank you, Jake, for facilitating. So,
Absolutely. And if you have any questions for myself or Sandy's contact information is also available. Just reach out.
thanks.
All righty. Thank you, everybody. Take care. Have a great day.
Bye, everyone.